there, I'm Jenna Layton, the Vice President of Legislation for San Diego SHRM, and I'm back with another legal update. Don't forget to check back every month, as I'll be bringing you the most current information you need to know in order to be up to date on the legal issues that are affecting California's employers. This month, I'll be focusing on the U.S. Supreme Court's landmark ruling, which upheld critical portions of the Patient Protection and Affordable Care Act. During 2010, Congress passed that act in order to increase the number of Americans covered by health insurance and decrease the cost of health care. One key provision of that act is the individual mandate, which requires most Americans to maintain minimum essential health insurance coverage. For individuals who are not exempt and who do not receive health insurance through an employer or government program, the means of satisfying the individual mandate is to purchase insurance through a private company. Beginning in 2014, those who do not comply with the mandate must make a shared responsibility payment to the federal government. The Act provides that this penalty will be paid to the Internal Revenue Service with an individual's taxes and shall be assessed and collected in the same manner as tax penalties. Another key provision of the Act was the Medicaid expansion. The current Medicaid program offers federal funding to states to assist pregnant women, children, needy families, the blind, the elderly, and the disabled in obtaining medical care. The Act, as it was initially enacted, would have expanded the scope of the Medicaid program and increased the number of individuals the states must cover. Pursuant to the terms of the Act, as it was enacted during 2010, if a state did not comply with the new coverage requirements, it might lose its federal Medicaid funds. Shortly after the Act was passed, 26 states, several individuals, and the National Federation of Independent Business brought suit in federal court challenging the constitutionality of the individual mandate and the Medicaid expansion provision. The Court of Appeals for the 11th Circuit upheld the Medicaid expansion as a valid exercise of Congress's spending power, but concluded that Congress lacked the authority to enact the individual mandate. The Supreme Court, however, concluded that while the individual mandate is not a valid exercise of Congress's power under the Commerce Clause, it may properly be upheld as being within Congress's power under the Taxing Clause. That is, the shared responsibility payment may, for constitutional purposes, be considered a valid tax. On the other hand, the Supreme Court held that the Medicaid expansion violates the Constitution by threatening states with loss of their existing Medicaid funding if they decline to comply with the expansion. Essentially, the court found that the Constitution does not give Congress the authority to require states to regulate, and when Congress threatens to terminate other grants as a means of pressuring states to accept a spending clause program, the legislation runs counter to the nation's system of federalism. While the health care debate will likely wage on for many years to come, the Supreme Court's ruling sends a clear message. Employers need to review their plans and seize this opportunity to create better strategies around their health plans, both in design and in employee communication. Employers should continue to move forward with implementing and complying with the Act, since major portions of it take effect in 2013 and 2014. For example, many employers soon will be required to report the value of employer health coverage on IRS Form W-2, and all employers must issue a summary of benefits and coverages to their employees. Other steps employers should consider taking include determining the strategic implications of whether or not to offer a plan, and reviewing their existing plans to determine if they meet qualifying eligibility and affordability standards. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please contact me at 858-509-5696. You can also contact me by email at jlayton, that's J-L-E-Y-T-O-N, at pettitcohn.com, P-E-T-T-I-T-K-O-H-N.com. That's all for this month's legal update. I'll be back next month with more of the information that you need to know.